Hello viewers, welcome to LawPutra's YouTube channel, and today we will be dealing with different modes of execution of a decree in Civil Procedure Code. Now, execution we all know is the enforcement of a decree or order by the process of the court so as to enable the judgment creditor to recover the fruits of judgment passed in his favor. Now, the substantive provision, that is section 51, merely enumerates different modes of execution in general terms, while the conditions and limitations under which alone the respective modes can be availed of are prescribed further by different provisions, that is order 21. The code provides various modes of execution of decree, and it is open to the decree holder to choose any mode of execution of decree. Section 51 enumerates the various modes, which are as follows. The very first one is delivery of any property is specifically decree. Okay, so in this we have two cases. First is where the decree is for any specific movable property. It may be executed either by seizure and delivery of the property, or by detention of the judgment debtor, or by attachment and sale of his property, or by attachment and detention both. This has been given in order 21, rule 31. Now the next one is that what powers does the court have regarding the execution of immovable property? This has been addressed in Rule 35 and 36 of Order 21. Rule 35, Sub-Rule 1 basically says that the delivery of the property to be made to the decree holder, and if he has appointed a person on his behalf, then to that person it can be given or delivered. And if suppose in this property somebody is already occupying this property, then it's the duty of the court to vacate the property and ask that person to leave that property. And after that only it would be given to the decree holder, and possession delivered in this manner is known as actual or khas possession. Under it, sub-rule number 2 says that if such property is in the possession of a tenant or other person entitled to occupy the same and not bound by the decree, then the delivery of the property should be made by affixing a copy of the warrant at some conspicuous place on the property and proclaiming to the occupant by beat of drum or other customary mode at some convenient place the substance of a decree regarding the property, and this is known as symbolical or formal possession. Further, sub-rule 3 of this rule says that where the person in possession and bound by the decree does not afford free access, the officers of the court may, after giving reasonable warning and facility to a pardonation lady to withdraw, break open into the building and put the decree holder in possession thereof. Okay, so the second mode which we have is attachment and sale, or sale without attachment of property. According to section 51 clause B, the court may order the attachment and sale of property or the sale of property only. Section 60 clause 1 declares that what properties are liable to attachment and sale in execution of a decree and what properties are exempt therefrom. It provides the list of properties which are liable to attachment and sale in execution of a decree. That is land, houses or other buildings, goods and money, banknotes and checks, bill of exchanges and promissory notes, hundis, government securities, bonds and other securities for money, debts, shares in the corporation, and all other saleable property that belongs to the judgment debtor, which can be movable or immovable. And section 61 provides a partial exemption of agricultural produce. According to section 64 of the CPC, if any private alienation or transfer of property after the attachment is made, then the transfer would be considered as void. If the property is located within the court's local territorial jurisdiction, the court has the authority to attach it, and the fact that the judgment debtor's place of business is outside the court's jurisdiction is irrelevant. Here, attachment just entails that the judgment debtor may not transfer or create encumbrance over the property thereafter. This is given in rule number 54. So, rule 54 provides for the attachment of immovable property and the procedure for the proclamation of such attachment. Next mode which we have is arrest and detention in prison of the judgment debtor. This has been dealt in section 51 clause C plus section 55 to 59 along with rules 37 to 40 of order 21. However, clause C should be read subject to the proviso to section 51, which lays down that where the decree is for the payment of money, detention should not be ordered unless after giving the judgment debtor an opportunity of showing cause. The court is satisfied that there is not a mere omission to pay, but an attitude of refusal on demand verging on dishonest disowning of the obligation under decree. The simple default to discharge is not enough. There must be some element of bad faith beyond mere indifference to pay. This was held in the case of Jolly Verghese versus Bank of Cochin. And the proviso is also applicable where the judgment debtor is likely to abscond. Further, the court must record reasons for the committal of the judgment debtor to civil prison. Section 55 of the Code of Civil Procedure deals with various rules regarding the arrest and detention. According to this section, the judgment debtor can be arrested at any time of the day and can be brought before the court. Moreover, the detention of the judgment debtor should be in civil prison, and no officer can enter the dwelling house after sunset or before sunrise for making an arrest. And the last thing is the officer should release the judgment debtor once the amount is paid. Moreover, a decree for money cannot be executed by arrest and detention where the judgment debtor is a woman or a minor or a legal representative as specified in sections 56, 50 and 52 respectively. Section 58 lays down that no order of detention can be passed where the total amount of decree does not exceed rupees 2,000. For a sum of rupees 2,000 to rupees 5,000, detention period will be up to 6 weeks. And for a sum exceeding rupees 5,000, detention could be up to 3 months as amended by the 1999 amendment. Section 59 of the Code of Civil Procedure provides the judgment debtor can be released on the grounds of illness. Rule 39 of Order 21 is an important provision that deals with the subsistence allowance. The decree holder has to pay a certain sum that is fixed by the court for the maintenance of the judgment debtor in the civil prison from the time of his arrest until he can be brought before the court. No judgment debtor can be arrested if the decree holder has not paid the subsistence allowance. Next mode which we are going to deal with is appointment of receiver, section 51 clause D. Execution by appointment of receiver is known as equitable execution and is entirely within the court's discretion. It cannot be claimed as of right. Order 11 of the CPC includes the various provisions regarding the appointment of the receiver. It is an exceptional remedy and a very strong case must be made out in support of it. A decree holder cannot be permitted to pray for the appointment of receiver in respect of property which cannot be attached. Okay, now we would be discussing some other modes of execution which the nature of the relief granted may require. First is partition under section 54. When a decree is for partition or separate possession of a share of an undivided estate assessed to the payment of revenue to the government, it should be made by the collector. Next is specific performance of contract or injunction, Rule 32 of Order 21. When a decree is for specific performance of a contract or for the injunction and the party against whom it has been passed has willfully failed to obey it, it may be executed by his detention or by attachment of his property or both. Next is by payment of money, Rule 30 of Order 21. Where decree is for payment of money, even as an alternative to some other relief, it may be executed by detention or attachment and sale of property or both. Next is restitution of conjugal rights. According to Rule 32, if a party willfully fails to obey a decree of restitution, it may be executed by the attachment of property, and according to Rule 33, if the decree is against the husband and he does not comply with it in a fixed time, the court may order him to make periodical payments to decree holder. Further, we have execution of document or endorsement of negotiable instrument. Where a decree is for the aforesaid purposes and the judgment debtor neglects or refuses to obey the decree, the court shall, after giving an opportunity to the decree holder as well as the judgment debtor to prepare a draft or endorsement in accordance with the terms of decree, execute a document, endorse a negotiable instrument. This is Rule 34. Further, according to Rule 42, where a decree is for unascertained rent or mense profits, or any other matter, the court may order attachment of the property of the judgment debtor before the amount due from him is ascertained. Further, the provisions relating to enforcement of liability of surety, decree against corporations, decree against firm, decree against legal representatives, etc., are also some of the other modes of execution of the decree. Moreover, we have a concept of simultaneous execution, which is an execution both against the property and the person of the judgment debtor, and which is allowed under Rule 30. But the court has discretion to refuse the same under Rule 21. Now, we have one important provision of execution of cross decrees as provided in Rule 18 to 20 of Order 21, which deal with set off of cross decrees and cross claims in ordinary suits and mortgage suits. If applications are made to a court for the execution of cross decrees in separate suits for the payment of two different sums of money passed between the same parties and capable of execution at the time by such court, then firstly, if the two sums are equal, then two decrees shall satisfy each other and no execution will be allowed to be taken out. Further, secondly, if unequal, then full satisfaction will be entered upon the decree for the smaller amount and part satisfaction upon the decree for the larger amount. And the execution will be allowed only under the latter decree for the balance. This is Rule 18. Rule 19 similarly provides for cross claims in the same decree. In order that this rule may apply, the decree holder in one decree must be the judgment debtor in the other decree, and each party must fill the same character in both suits. So this was all regarding the modes of execution of a decree. Hope you would have liked and understood the topic. Keep learning and keep smiling. Thank you.